Hello, my name is Agnieszka Kałdonek and I work at the Institute of English Studies at the Warsaw University. Today, I have prepared a lesson for you that is linked to one of the courses I teach at the Institute. The lesson concerns English for legal purposes. Like my students, you may think that we are going to learn about murder mysteries or crime dramas, but we are going to go beyond these topics. So what are we going to learn today? Our keyword today is tort, or rather, tort. We are going to learn or define the law of tort, and we're going to learn about vocabulary related to the law of tort. Before we define the law of tort, I want you just to make an adjective from the word tort. On your left, you have some typical adjective endings. So what do you think? What's the adjective from the word tort? The adjective is tortious. For example, tortious activity. So what's the law of tort or tort law? This is the area of law that covers most of civil suits as opposed to criminal suits. The concept of this area of law is to redress a wrong done to a person and provide relief from the wrongful acts of others, usually by awarding damages as compensation. The original intent of tort is to provide full compensation for proved harms. Just let's focus on specific vocabulary. To redress is to remedy or to compensate. And another word I would like you to remember are damages. So damages are a remedy in the form of a monetary award. Now we are going to learn about negligence. I would like you to watch this 4-minute video and write down some words related to negligence.
In this video, we will introduce negligence. We'll say Perry is crossing the street, and just then, Dudley comes riding by on his bicycle into the intersection too fast, and there's an accident, and Perry gets hurt. In everyday conversation, we would say that Dudley was careless and that his carelessness caused the accident. But if the parties go to court, we would say that this is a case about negligence. The defendant is being sued for being negligent. Negligence is another name for an unintentional tort. In law school, you'll frequently hear people say that a plaintiff must prove duty, breach, causation, and damages to win a negligence claim. That's a short way of saying that the elements of negligence are the defendant owed a duty of reasonable care to the plaintiff, the defendant breached that duty of reasonable care, and as a result of the breach, the defendant caused damages to the plaintiff. So using our bicycle accident as an example, let's look at the elements of negligence: duty, breach, causation, and damages. And we'll start with duty. By duty, we mean that the defendant had an obligation of reasonable care to avoid causing this type of injury. To determine whether that obligation exists, courts will often ask whether the accident and the injury were foreseeable. In this case, everyone would probably agree riding a bicycle too fast through a crosswalk can foreseeably cause an injury to a pedestrian who is crossing the street. For this reason, the element of duty is probably satisfied. Dudley had a duty of reasonable care to avoid this type of injury to Perry. Next, let's look at breach. To determine whether Dudley breached his duty of reasonable care, a court will probably compare Dudley to the reasonable person. If the defendant's level of care went below the level of care that we would expect from a reasonable person, we would say the defendant breached his duty of care. So using this chart as an example, we would say that whenever the red line goes below the blue line, the defendant breached his duty of care because he showed less care than the reasonable person would. Turning back to our case, people would probably say that a reasonable person would not speed through the crosswalk, and instead, a cyclist would slow down or stop. For this reason, Dudley was not as careful as he should have been. He was not as careful as the reasonable person, and therefore, he probably breached his duty of reasonable care. Next, we'll look at causation. At this point in its analysis, a court will ask whether the defendant's breach of his duty of care caused the plaintiff's injury. In fact, courts discuss two types of causation, actual cause and proximate cause. We're not going to discuss those in too much detail, but actual cause means if the defendant had done something differently, would the accident still have occurred? For proximate cause, we ask whether the defendant's actions were close enough in time and space to the injury. Based on the facts as we understand them, it seems the defendant did cause the accident, because if he had stopped or ridden more slowly, there would not have been an accident. So it looks like the third element of causation is also satisfied. Now let's look at damages briefly. It seems that there's no dispute that the plaintiff was injured as a result of Dudley's actions. Therefore, we can say that all four elements of negligence have been satisfied. We can predict that Perry will win in his lawsuit because he should be able to prove all four elements of negligence.
Right, so these are the words I have written down. So careless, unintentional tort, defendant, plaintiff, to owe a duty, to breach a duty of care, causation, reasonable care, to cause damage, foreseeable in the context of an accident, and a reasonable person. Now I would like you to do this small task. So in the sentences, I want you just to find the missing word. And I believe 1 minute should be enough. So have a try. All right, so let's just look at the first sentence. The first missing word is unintentional. So another name for negligence is unintentional tort. The second one and the third one is breach and damages. The plaintiff needs to prove 4 elements of negligence to succeed with their claim in court. These are duty, breach, causation, and damages. And the last missing word is foreseeable. Courts will often ask whether the accident was foreseeable. Okay, so now I would like you to learn about a very famous negligence case. So we are going to watch 4 minutes of this video. And while watching, I would like you to find the answer to 3 questions. So the first question is, how much was the plaintiff awarded? The second question is, why was the plaintiff awarded damages? And the third question, how many times did the plaintiff's lawyer try to settle the case out of court?
In Albuquerque, New Mexico, an elderly woman was severely burned when she spilled a cup of McDonald's coffee in her lap.
An 81-year-old woman has been awarded $2.9 million after she sued McDonald's, claiming their coffee was too hot.
Stella Liebeck spilled just 8 ounces of coffee, but she attracted a flood of attention. The jury's award set off a media frenzy and became a rallying cry for those who believed our legal system had run amok.
I think it's absurd.
But as her story cycled through newspaper headlines, talk show storylines, and late-night punchlines, one thing was lost: the facts.
This story is the most widely misunderstood story in America. The public perception of it is Stella Liebeck won a lottery. She bought the coffee, she spilled it on herself, and now look, she's a millionaire. When, of course, the facts are much more complicated than that.
Stella Liebeck was a 79-year-old widow sitting in the passenger seat of a parked car when she was burned on February 27, 1992. She had recently quit her job as a department store clerk and moved to Albuquerque to be near her daughter.
The day that the burns happened, my mother and my nephew went through the drive-thru at McDonald's and got breakfast and coffee, and they pulled into the parking lot. And in the Ford Probe, there's slanted surfaces everywhere. There's no place to put the coffee. She put it between her knees and lifted the lid off, and in the process of doing that, spilled the coffee, and all of the hot liquid went into the sweatsuit that she was wearing and pooled in the seat.
All I remember is trying to get out of the car. I screamed, not realizing I was burned that bad. I knew I was in terrible pain.
The severity of the burns caused Stella Liebeck to go into shock, and her grandson immediately took her to the emergency room.
She was burned over 16% of her body. 6% of the burns were 3rd degree. She was in the hospital for a week.
Medical bills were $10,000, so Stella reached out to McDonald's and asked to be reimbursed.
We couldn't believe that this could happen over spilling the coffee. So we wrote a letter to McDonald's asking them to check the temperature of the coffee and to give recompense for the medical bills. And the response from McDonald's was an offer of $800.
Stella Liebeck had never sued anyone before Albuquerque attorney Ken Wagner took her case. Before they went to trial, they tried twice to settle out of court, but McDonald's refused.
We bought a product, it was used as intended, it was unreasonably hot and therefore unreasonably dangerous, and those were the essential facts.
I was not in it for the money. I was in it because I wanted to bring the temperature down so that other people will not go through the same thing I did.
McDonald's policy was to serve coffee between 180 and 190 degrees. That's about 30 degrees warmer than most home coffee brewing machines. A burn expert testified that liquid at 180 degrees could cause 3rd-degree burns within 15 seconds. Lawyers produced documents that showed that between 1983 and 1992, nearly 700 people claimed that they had been burned by hot coffee at McDonald's.
McDonald's was on big-time notice that they had a product that was dangerous and it was burning people. We argued that to the jury, that they were callous and indifferent in simply not turning down the temperature.
An expert for McDonald's testified that...
All right. So let's see the answer to the first question. So the first question was, how much was the plaintiff awarded? So it was $2.9 million. The second question was, why was the plaintiff awarded damages? The plaintiff, she was severely burned when she split McDonald's coffee on her laps. The coffee was simply too hot. And the third question was, how many times did the plaintiff's lawyer try to settle the case out of court? And the answer is twice. If you are interested in the case and just learn a bit more about this case, of course, you can watch the entire video. And while watching it, have these questions in mind. In your opinion, was the plaintiff right to sue? And what do you think about the media reaction? So this is the end of our lesson. In this lesson, we talked about the law of tort, more specifically about negligence. And I hope that you've learned some new words, for example, damages, foreseeable, or breach. So thank you for listening and good luck in your upcoming exams.